transparent about the factors animating the entry of nolle prosequi in some cases and the withdrawal of others is not only because I want to avoid accusations of partiality and or capitulation to political pressure, but also to comply with the constitutional requirements stated in Article 296 of the Constitution. More so, in the best ethics of the legal profession, every lawyer is mandated to act in the best interest of his client, and no lawyer worth his salt, his or her salt, will purport to act in the best interest of the client by doing so on the blind side of the client. As Attorney General, my only client is the Republic of Ghana, represented by its sovereign people. And as stated above, I intend to provide the reasons for my decisions in the cases in which I have either entered a nolle prosequi or withdrawn the charges laid against the accused persons. And I do so to my fellow citizens who have entrusted the power to me through the President of the Republic. Before I proceed to assign the reasons for my decision in each of the cases, I wish to crave your indulgence to provide a brief explanation of the technical difference between the entry of a nolle prosequi and the withdrawal of charges. The power to enter a nolle prosequi is contained in Section 54 of the Criminal and Other Offences Procedure Act 1960, Act 30. Pursuant to this provision, the Attorney General may enter a nolle prosequi at any stage of a criminal trial. The statute does not itself require the Attorney General to provide any reasons for his decision to enter a nolle prosequi in any proceedings. However, as I have made clear above, the constitutional principles in Article 296 impose an obligation on the Attorney General to be candid in the exercise of his discretionary power, and I cannot fathom how one can be candid without explaining one's actions. When a nolle prosequi is used by the Attorney General to terminate proceedings in a criminal trial, he reserves the right to bring fresh charges against the accused persons in the future. In contrast, the Attorney General may terminate criminal proceedings by withdrawing the charges against an accused person pursuant to Section 59 of the Criminal and Other Offences Procedure Act 1960, Act 30. Where the charges are withdrawn after the prosecution has closed its case, then the legal effect of the withdrawal is that the accused is deemed to have been acquitted and discharged. In other words, that accused cannot be brought back and tried on the same facts or for the same offenses. So in all the cases in which I have withdrawn the charges against the accused persons and in which the prosecution has closed its case, those accused persons are considered to have been acquitted and discharged. Ladies and gentlemen of the media and fellow citizens, my decision to terminate the criminal trial was animated in the main by three factors. On the charges against the accused persons and in which the prosecution has closed its case, those accused persons are considered to have been acquitted and discharged. Ladies and gentlemen of the media and fellow citizens, my decision to terminate the criminal trial was animated in the main by three factors. The first was that for ethical and professional reasons, I could not in good conscience continue to prosecute some of the cases. The second was that for some of the cases, my own review and analysis of the charges showed clearly that the charges were defective, and some were filed against the promptings of plain common sense. The third was that in some of the cases, the evidence led so far showed that there was a reasonable doubt as to the guilt of the accused persons, and no prosecutor should continue to pursue a case in the face of overwhelming doubt regarding the guilt of the accused person. Also, it is important to highlight the fact that in most of the cases in which I have terminated proceedings, the conduct of some of the individual judges left so much to be desired. I will deal with the issue of judicial conduct in my concluding remarks. Suffice it to say that it raises a specter of lack of fairness in criminal proceedings where a judge is seen to be overly hostile to the accused and unreservedly deferential to the prosecution. Now to my first substantive reason for dropping charges in some of the cases. As I have noted above, for purely ethical and professional reasons, I could not in good conscience continue to exercise my prosecutorial authority under Article 88, Clause 3 in some of the cases. These cases were the Republic versus Kesiel Atoforsen and another, and the Republic versus Ofosu Ampofo and another. This is because I was deeply involved as counsel in these two cases. In the case of Republic versus Atoforsen, I was not counsel on record, but my junior partner, Godwin Kujo Tamaklo, also known as Eduji, was a counsel on record. As a team, we discussed our strategy in chambers, and I was involved in reviewing legal arguments and in some instances, authoring some of the arguments that we filed in court. I believed then, and still believe now, that the Honorable Atoforsen was a victim of a political witch hunt and that he had no case to answer in that trial.